Zaragoza v. Garland out of the Seventh Circuit. I'll be much quicker with this. This is the matter of Thomas and Thompson issue. Matter of Thomas and Thompson was the Attorney General Barr's decision that said essentially it vacated 3 BIA decisions. I've got them in front of me. It's matter of what 3 decisions? Matter of Cota Vargas, matter of Song, and matter of Estrada, which all talk about what happens when criminal convictions get vacated, modified, amended, like all these different things that can happen in states, even if they're for immigration purposes. Matter of Song, Cota Vargas, Estrada said essentially that the immigration courts need to defer to what the state court is doing. It was only matter of Pickering that I believe it was with vacated convictions that it said it has to be vacated for procedural or substantive or constitutional defects. Can't be for immigration purposes, rehabilitative purposes, any of that. Song, Cota Vargas, and Estrada with like amendments and modifications, I think was letting that stuff in. But vacated convictions had to be procedural or substantive for immigration law to give it effect. In matter of Thomas and Thompson, Attorney General Barr said, out with those other 3 BIA decisions. The only thing that's good law is matter of Pickering. So any amendment, modification, vacation, anything to a criminal conviction, it's got to be for procedural substantive defect, or immigration is gonna listen to it. It's a very harsh rule for non-citizens. When the state says we don't want this person to have the consequences anymore, immigration will turn around and say we don't care. We're still going to punish them.
Interesting. Really, the administration is still fighting that, but I thought they would have let that go or something.
Yeah, I mean, look, Attorney General Garland could vacate matter of Thomas and Thompson and put back into effect the 3 published BIA decisions, but he has not done so yet. The Seventh Circuit decision, Zaragoza v. Garland, unfortunately says that Thomas and Thompson is okay. It says that the Immigration Nationality Act is ambiguous. And so what the Attorney General did was reasonable. But it said that it has to apply prospectively, can't apply retroactively. So that's a bit of a win for non-citizens. So sentence modifications, amendments, all that stuff that happened before matter of Thomas and Thompson was published, which I want to say is in 2019, might be 2018. Oh, it is. It's October 25th, 2019. That's still good. That's still the old framework. Oh, so so Thomas and Thompson doesn't apply retroactively in the Seventh Circuit, but of course you could argue that everywhere.
Okay, and I understood your respect percent. Oh, that's good. Okay,
right. Yeah. So I mean that's something. It's not good. I would have preferred that the Seventh said this is not reasonable, but who am I? Again, Attorney General Garland can do that, and then what Attorney General Garland would do would then be deferred to in the Seventh, because again, the Seventh has just said that the statute is ambiguous, and we're going to defer to what the Attorney General says. So really, Attorney General Garland could do it. I'm sorry, I'm just getting over a bit of a cold. I'll cough one more time.
I got that too. I haven't published a podcast in like weeks. It's like getting sick, get better, and then this cough. I was like, that's what we canceled last week. It was terrible. Everyone's probably getting this one. It's funny you mentioned matter of Estrada, and in my head, because I do adjustment and stuff like that a lot. Like matter of Estrada is a 245I case, and I'm like, okay, there's 2 matter of Estrada.
Maybe there's probably a lot of Estrada.
Yeah, that's a popular last name.